Hi, I'm Steve Bohm, and I'm here with my colleague, Ann Oberndorf, and we're going to talk to you today about hot topics and emerging trends in co-investment and generally in exemptive relief. This is a very active area, as many of you know, for BDCs, particularly BDCs on platforms with multiple other funds. In terms of co-investment, why do we need relief? We need relief because the 1940 Act is geared to protect BDCs and other 40 Act registrants from overreaching by affiliates, mostly the investment advisor and other funds managed by the investment advisor. There is a specific provision under the 1940 Act, Section 57A4, which prohibits so-called joint transactions. A joint transaction generally is any transaction in which a BDC on the one hand and a affiliated fund on the other are both entering into a transaction in which each has a financial interest. Now, while generally very amorphous, we do know that in the area of co-investment, it is very clear that a typical negotiated co-investment transaction implicates the joint transaction prohibitions. Before we start talking about specific areas of co-investment and other relief, Ann, can you give us some statistics that might be of interest to our audience?
Sure, thanks, Steve. I like to follow the statistics on co-investment orders because it's something that I'm interested in, and we can see what the staff is doing each year and what other BDCs are doing each year. So we follow this, and I personally thought it was interesting that 99 co-investment orders have been granted to date. Now, some funds have gotten multiple orders and some funds are not around anymore, but that's a lot of orders. Back when we first started following these, there were not that many orders. Now, last year in 2019, only 8 co-investment orders were granted, which was a sharp decline from the 19 in 2017 and the 18 in 2018. One of the reasons for the decline may be because the staff was focused on the FS application, which I'll talk about in a minute. And other BDCs might have also been waiting to see what happened with the FS application. This year, in 2020, there have been 12 applications that have received orders so far and 2 notices pending, and there are still 4 months left in the year. So it looks like that number will be back up to where it's been before.
And you mentioned the FS application, which, if granted in some form, would fundamentally change the landscape for co-investment relief. Now, I guess we have reason to not have too much hope at this point, but I think it's important for our audience to understand what that application is, should it eventually become form.
Exactly. So the FS application is something that's been floating around for quite some time now that the staff has been wrestling with. And if ever granted, it would present a more efficient process for co-investment orders. And in essence, what it would do is shift the responsibility of monitoring the co-investment program from the board to the investment advisor. So that would be a really big change, and that's why this is something that we do follow. Some of the other changes that the FS application would make, which are good to know about just because it would be such a difference, is that it would change the rigid 15 conditions we're used to seeing to 8, and there are 8 principle-based conditions as opposed to being very specific on what you have to do. So for example, in the standard co-investment application, the BDC has to be made aware of every co-investment opportunity that falls within its very broad objectives and strategies. In the FS application, there's no such requirement. The advisor is responsible for coming up with policies and procedures that ensure that the BDC will be treated fairly. So that's a big difference. In addition, as Steve mentioned, I think board approval is a cornerstone of the co-investment application right now, and the board has to approve almost every co-investment done on the platform. In the FS application, board approval is not required for initial co-investment transactions. Further, the standard application right now has many blanket prohibitions. For example, if an affiliate is already invested in an issuer, the BDC cannot co-invest in that name, which can be very problematic. That prohibition is not included in the FS application. That type of transaction can be done with board approval. So those are just some of the changes that would be made, and that's why we are interested in this application. Now, as to where we are with this application today, just a little background on it, it actually started as a no action letter in the spring of 2018. The staff discussed it with us and several other law firms, and we, of course, were very excited because what that meant was BDC platforms would no longer have to file their own individual co-investment application, and they could rely on this no action letter. However, nothing happened with it. until April of 2019, a year later, FS Global Credit Opportunities filed a co-investment application that looked eerily similar to the no action letter and had all the same terms and conditions. So we once again got interested to see if this change was going to happen and at least everybody could get their own application and have these different terms. And a month later, FS filed an amendment to their application with not many changes, which typically signifies that the staff is almost done with their review. So again, everyone got excited that this might be happening, but nothing did end up happening. And as of the roundtable last year, there were 3 applications filed that reflected the FS conditions, and we were all kind of waiting to see what happened. And then this spring, in March of 2020, there was yet another application filed with the FS conditions, and we once again thought, is it happening? And we spoke to the staff, as we do from time to time, and they let us know that that application was filed on its own, and at this time, they're really not interested in making any major changes to the co-investment relief.
Yeah, it's a bit of a tease, because if this style of relief were in fact to be granted, it would really change the landscape we think in a very positive way. And I'm sure boards of directors would love to see it because it would take a lot of the onus off them and put it on the advisor. But again, at this point, it has been shelved. We're hoping maybe with a change of administration, it might become unshelved. But I think it's important for everyone to know it's out there. And on another subject of, I think, substantial interest to many BDCs is how the staff is dealing with co-investment relief, where there's a sub-advisor involved. I know the staff has granted some relief in that way, but they're hesitant in other ways. Can you walk us through that, please?
Sure, yes. This is another area that we monitor and discuss with the staff. Steve went over the basic structure of co-investment relief earlier. Then the question is, what happens if you have your investment advisor and the funds on your platform, but the investment advisor would like to sub-advise a fund that's not on your platform? The staff has granted relief for this. And typically, how it works, when the relief was first granted, you had to add that fund and its unaffiliated investment advisor to your co-investment application. And that was kind of a pain because if you were trying to enter into a sub-advisory relationship, you had to tell the sub-advisory client that first you had to get co-investment relief. So this is something we've spoken with the staff about and we've been trying to change. And last year, we thought we had a breakthrough. There were 3 precedents last year, orders, and the application included some language that was broader and more general. For example, when it was defining future regulated funds and future affiliated funds, it said that the investment advisor or the sub-advisor was an advisor on the platform. And it did not speak to the unaffiliated investment advisor. There were no requirements around that. So it did not have to comply with the conditions or sign on. So that really seemed like a big breakthrough. And what it meant is that you could cover future sub-advised funds without coming back and amending your application each time to add those funds and their investment advisors as applicants. However, later on last year, towards the end of the year, when we were dealing with a co-investment application, we spoke with the staff and they made it clear that they did not intend for the language to get this broad. And they walked it back and said, they do think you should have to come back and file an amendment every time you're sub-advising a new fund with an unaffiliated investment advisor, and that the fund and its investment advisor should sign on as applicants. And in every co-investment application that has been granted an order since then, it's had the narrower language that makes this point clear. The one point they did make clear is that you can have a sub-advisor and an advisor on the same platform, and you certainly don't have to go back for an amendment for that. So if, for an example, you have an investment advisor on your platform and another investment advisor is going to serve as a sub-advisor, that's certainly fine. So what this means is that now applicants have to go back and get an order every time, and that's disappointing. But we're still talking with the staff. We're hoping to make breakthroughs, and there are more areas regarding sub-advisors that we're discussing. For example, the next slide depicts another area of sub-advisor relief that we're discussing and just shows how complex this area can be. For example, there may be funds that have different sleeves that do different types of investing. And ideally, they have sub-advisors from different platforms. And of course, each platform would like the sleeve that they're sub-advising to co-invest with their own platform. Right now, this is not something the staff is willing to consider. And this is something that we and others have talked to them about, and we're going to continue to talk to them about.
Thank you, Anne. Not too many good things have come out of the pandemic, but one thing the staff has done, which has been necessary for BDC, has been a new temporary rule that grants some greater flexibility in the follow-on co-investment area. Can you tell us what the problem was that they were seeking to address?
Sure, Steve. So yes, the question we get a lot is, what happens if you have a new fund on the platform that did not participate in an initial co-investment transaction, or a fund that just didn't participate in an initial co-investment transaction? What happens when you're doing a follow-on? How do you treat those? Can they participate? And the requirement right now, typically with a standard co-investment application, is that only entities that participated in the initial co-investment transaction can participate in a follow-on. This can be very frustrating because, especially on these BDC platforms, private funds have a finite term and they may be winding down. So if a portfolio company comes to the platform and wants more money, wants them to do a follow-on, the BDC may be the only entity that participated that still has capital, which means they may end up investing more money than is appropriate for them, or they may not be able to fulfill the commitment to the portfolio company if they don't have enough money on their own. So this has been frustrating. It's something we've discussed with the staff. And Steve, can you tell us about the recent breakthrough?
Yes, the staff has passed a temporary rule, which will stay in place until December 31st. We hope that it will have no reason to believe that's in the works. And what the rule does is solve the problem that Anne was talking about. And that is, now if a private fund has not invested in the original investment, the original co-investment, either because it was not around or because it simply didn't participate, that private fund can now participate in the follow-on as long as it does not otherwise hold the securities. In other words, it might have acquired the securities of that issuer other than through the initial co-investment. Probably an unlikely scenario, but that is a requirement. We think this is very important. As Anne said, we've been pushing for this for years. It certainly well beyond the would allow BDC to access more deals to the extent it provides another source of capital where the ability to get a deal depends on greater scale than the BDC can offer. We believe that, although we're grateful for the temporary nature of the relief at all, we believe that, frankly, this should be a no-brainer. If anything, it's salutary, just like any other follow-on investment scenario. And we're hoping that the staff would at least consider making this permanent or extending the temporary period for the rule. I want to talk now a little bit about process. I think we're all aware that the exemptive application process ordinarily is a long one. Under the staff's current internal guidelines, when an application is submitted, they have 120 days to submit comment. Now, the reality is that in most cases, in our experience, at least until recently, the staff took all or just about all of the 120 days. Of course, the next step is we receive comments, we respond to comments, and it's also our experience that after the first round of comments, when they again have 120 days, they tend to take a large portion, if not all the 120 days. So you're sitting 240 days, worst case, and you've gotten 2 rounds of comments, and usually it takes a little bit more than 2 rounds of comments to get through. The bottom line is that even in routine applications for which there's ample precedent, we're talking about 6 to 9 months to get the relief. Very frustrating. A lot of the timing depends on how busy the staff person is on whose desk the application falls. So there's some randomness to it. And this is not to suggest that the staff is not doing a great job when they do review the applications, but the timing is a problem. And not only can applications take 6 to 9 months, but we've had some experience in the co-investment area where applications took over 5 years. What the staff has done to address this, Anne, do you want to talk about that?
Sure, Steve, thanks. So the SEC adopted amendments to Rule 0-5 in July, which governs the review of exemptive applications, and they created a expedited review of routine applications. So what does that mean? A routine application is an application that is substantially similar to at least 2 other applications for which an order granting relief has been issued within 3 years of the filing date. So what does substantially similar mean? That means that you're requesting relief from the same sections of the 40 Act. The application contains identical terms and conditions and differs only in terms of factual differences that are not material to the requested relief, like the names of the applicants and the formation jurisdiction. So very similar. There are also other requirements to qualify for expedited review. The applicants have to make a notation on the cover page of their application requesting expedited review. They have to file as exhibits marked copies of the application marked against the two precedents they're using. And the applicants have to file a cover letter explaining why they chose the two precedents they're using, as well as certifying that they believe their application meets the requirements for expedited review. So if they do meet the requirements for expedited review, what does that mean? That means that if everything goes right, the SEC should issue the notice no later than 45 days from the date of the filing, unless they determine that the application does not meet the requirements for expedited review, or there's some other reason why they need extra time to review it. Now, the 45-day time period can pause if the SEC determines to issue comments on the application. The 45 days will pause until 14 days after the applicants refile their amendment addressing the comments. In addition, if the applicants on their own decide to file an amendment, then the time period pauses for 30 days to give the staff time to review that amendment. And then after that 30 days expires, the rest of the 45 days will continue on. Interestingly about this rule is that in the proposing release, the SEC did note a few areas where they just thought that point blank, these types of applications would not qualify for expedited review. They mentioned co-investment relief. They mentioned exemptive applications regarding control under Section 2A9 and a few other areas. However, in their final release, they said they were not going to strictly rule out any areas, although they did think many of those areas would have trouble qualifying. And they did note, however, that co-investment applications that met the requirements for substantially similar could qualify for expedited review. So, for example, there's been over 35 co-investment orders granted in the last 3 years, and they typically have similar conditions. So I think that we might be able to see some co-investment applications qualify. It'll be interesting to see. Now, if an application cannot qualify for expedited review, the SEC also adopted a new timeline for what they call novel applications. Those are applications that are not routine. Now, instead of taking the 120 days typically allowed to review an application, as Steve was discussing, the amendments state that the SEC should take action on an application within 90 days of the filing of the initial application, and each of the first 3 amendments thereto. And any subsequent amendment should be addressed within 60 days of the filing. So what that means is there might still be a number of filings back and forth, but at least the staff is going to try to move through them at a quicker pace. Now, this new rule is not effective yet. It won't be effective until 270 days after it's been published in the Federal Register. But already we're noticing the staff is trying to get through applications on a faster timeline and getting back to applicants faster, which we really appreciate the effort. It will be interesting to see, however, once the rule is adopted, how the staff works with this 45-day time period for expedited review. Steve, can you tell us about an update on multi-class applications?
Yes, last but far from least, there was a very, very significant development in February when the SEC granted an order permitting FS Energy and Power to implement a so-called multi-class structure. Multi-class structure refers to a structure in which a fund has different pricing, different charges, depending upon the manner in which the investment is made, whether it's made through a broker, whether it's made directly, or in some other fashion. Multi-class structures have been very common in the mutual fund area and also common in the closed-end, continuously offered fund area. For mutual funds, there's a specific rule, 18F3, permitting multi-class structures, and closed-end funds have routinely gotten for many years. Because closed-end funds have gotten relief for many years, the industry's been a little frustrated as to why BDCs that are continuously offered and not traded can't have the same relief. Well, that same relief was granted in February, as I mentioned, and in fact, another notice is pending, and a third BDC has an application pending. So we think this is going to be very significant. What does the multi-class structure look like? Basically, you're permitting different types of sales charges. You might have a contingent deferred sales load, which is on the back end. You might have a front-end sales load. You might have an asset-based sales load, which looks a lot like what mutual funds call 12B1 plans. What this allows is greater asset accumulation because you have different spigots, if you will, through which investors can put money into the fund. The SEC specifically recognized the importance of greater asset accumulation as a justification for this relief, noting the obvious that the more assets, the easier it is to spread fixed costs more broadly and reduce the cost per shareholder. What are the basic requirements under the application? First, you have to adopt a plan similar to what is required under 18F3 that sets forth how your multi-class structure is going to work. Second, you have to adopt a so-called 12B1 type plan. Mutual funds are required to have 12B1 plans where they have asset-based charges. And 12B1 plans basically set forth the manner in which the charges are made and demonstrates why it's in the best interest of shareholders to do so. And the board must approve it initially and again each year. And that requirement would be imposed on BDCs relying on relief of this nature as well. Finally, BDCs have to offer some form of liquidity, most likely in the form of a tender offer, so that investors can leave the fund in some way, to some extent, if the multi-class structure is put in place. As I said at the outset, I think this is very, very significant. Generally speaking, there has not been a lot of movement in the non-traded BDC space. However, with the ability to access capital, to access new investors through various distribution channels, which a multi-class structure would allow, I think it's safe to say that we'll be seeing more non-traded BDCs on the horizon. We want to thank you for joining us today. It was a pleasure to speak with you. If you have any questions or need more information, feel free to reach out to Ann or me, or go to our website at www.publiclytradedequity.com. Have a great day.